Good evening, everyone, and welcome to the National Constitution Center. My name's Allison Young. For those of you who are just joining us for this portion of the program, I am the Vice President of Public Engagement here at the National Constitution Center. And it's my pleasure to welcome you to the centerpiece event of the annual Peter Jennings Project for Journalists in the Constitution. The project is named for a man who was born a Canadian but so profoundly inspired the words and meaning of the Constitution that before his untimely death in 2005, he became a naturalized citizen of the United States. Through his work in front of and behind the camera, Peter inspired others to participate in constitutional dialogue, even lending his voice to the virtual tour of the center's core exhibit, which we opened in 2003. So as we prepare to celebrate next year the 225th anniversary of the Constitution, the discourse surrounding this extraordinary document continues to intensify. Recently, we seem to be faced daily with opportunities to really consider the words of our founding fathers and how they're impacting our everyday lives, and how in turn we're inspired to civic action. In that vein, this weekend, the National Constitution Center is privileged to carry on Peter's legacy by opening its doors to media professionals from around the world. This year, the Peter Jennings Project Fellows, who are joining me in the front of the room this evening, represent 5 countries and 19 states, and they're also diverse in terms of the types of media and reporting they represent. As journalists, they are performing a unique service in ensuring the integrity of our democracy by covering some of the most hotly debated issues of our day, including individual rights, equal protection, religious freedom, national security, and immigration, which is the focus of tonight's program. But you're here to learn and engage, so let's get to it. In just a moment, Todd Brewster, who is the director of the Peter Jennings Project, will set the stage for what you're about to experience and introduce our distinguished panel of speakers. I get the pleasure of telling you about Todd. Todd is a close friend of Peter Jennings. In addition to his work with the Jennings Project, he's the director of the West Point Center for Oral History. Todd's a veteran journalist who for more than 20 years covered national and international politics, working with Time and ABC News. He is co-author with Peter Jennings of the best-selling books, The Century and In Search of America. Todd's also taught journalism, documentary film, and constitutional law as a visiting professor at Wesleyan University. And he's a Knight Fellow at Yale Law School. Will you please join me in welcoming a great friend to the National Constitution Center, Todd Brewster.
Thank you, Allison, and welcome everybody to the Peter Jennings Project for Journalists and the Constitution main event. For those of you in the audience who are not Jennings Fellows, let me briefly explain, as I did a little bit earlier today at the moot court, but I think we may have some other non-fellows here. Peter Jennings, a Canadian who became an American citizen late in life, had great admiration for the Constitution. To honor him and his devotion to his adopted country, each year 42 mid-career working journalists are chosen as Jennings Fellows. They're then brought here to Philadelphia and the National Constitution Center for a weekend immersion experience in the Constitution and constitutional law. The fellows spent this morning at case workshops where they parsed out constitutional issues with federal judges and legal advocates, and the afternoon was spent at a moot court, and now they're here for our main event. The word immigration never appears in the Constitution, but the notion of identity, of national identity, hovers over its every word. The founders saw theirs as not simply a continental revolution, but a global one, claiming basic human rights, yet paradoxically they argued over who got to enjoy them, not only in the nearly fatal national clash over slavery that led to the Civil War, but also over which foreigners could come here and participate in the fragile American experiment. Jefferson feared that immigrants arriving from around the world would settle in America for the wrong reasons and bring with them the vices of the monarchical, or worse, the papist societies from which the American idea was such a radical break. He preferred to think of America as growing from within, with freedom-loving people begetting more freedom-loving people. Still, he never argued for limiting immigration. Jefferson's solution was, like so many things Jefferson, idealistic. He believed the country should neither discourage nor encourage immigration, leaving the precious human spirit to its own impulses, unimpeded and unpersuaded. That was in a country of 4 million people. What would he have made of our country of 300 million people? Certainly our contemporary dilemma carries some of the same dual impulses: pride in our immigrant character and fear for the fragility of the American values. The issue tonight, like all constitutional issues, revolves around language and its meaning. You will hear discussion of the Supremacy Clause and of the concept of preemption, both found in Article 6, Paragraph 2, and together declaring the Constitution and federal statutes as the supreme law of the land, even when it conflicts with the laws of the states. But the most delicate parsing of language tonight will come in the discussion of the 14th Amendment. When it was ratified in 1868, shortly after the Civil War, it included this phrase: all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the states wherein they reside. We know what it means to be born in the United States, but what does it mean to be subject to the jurisdiction thereof? And why do the authors of the amendment insert that phrase? Cecillia Wang, the managing attorney for the ACLU's Immigrant Rights Project, says that the phrase was merely meant to exclude the children of diplomats and soldiers of hostile armies. Pennsylvania State Representative Daryl Metcalfe counters that it is beyond dispute that the original intent of the phrase was to separate out those with allegiance to any foreign sovereignty, which he reads as excluding the children of illegal immigrants. Like many who favor a more robust and confrontational policy towards illegal immigration, Metcalfe sees these anchor babies, a term that has come to negatively describe this impulse, as one of the three main incentives, jobs and public benefits being the others, drawing illegal immigrants to the United States. Activists on this side of the question seek either an amendment or a reinterpretation of the Birthright Citizenship Clause. Both Daryl Metcalfe and Cecillia Wang are with us tonight, in what will be an exciting program examining the constitutional dimension to the very contemporary problem of immigration reform. Our program carries a special format. It was built from a model that was pioneered by the great CBS News producer Fred Friendly more than 30 years ago, in which participants appear on the stage in the roles they occupy in real life. The moderator today, CBS News' Jeff Greenfield, and the author of a new book, Then Everything Changed, which received a rave review in the New York Times this week. Then we'll weave a hypothetical situation before them, bringing the participants into the discussion to ask, what would you do here? How would you react once this happened? And what impulse drives your next move? Not only is the Constitution about language, you see, it is also about stories. Along with Daryl Metcalfe and Cecillia Wang, our participants today include John Eastman, the Donald F. Kennedy Chair in Law and Director of the Center for Constitutional Jurisprudence at Chapman University School of Law in Orange, California. Federal Judge Marjorie Rendell of the Third Circuit Court of Appeals here in Philadelphia, and Jorge Mursuli, President and CEO of Democracia Ahora. And then some of the members of our audience will be participating today too. Fellows of the Peter Jennings Project. In preparation for tonight's event, and this is an experiment, the 42 fellows have each been assigned one of four, or actually one of six identities: immigrants, legal and illegal, strict enforcement advocates, business people who oppose limits on immigration, and law enforcement officers either who support or reject immigration restrictions. Finally, I'd like to thank Joan Greco, who has worked for years with the Fred Friendly Seminars Group and who's helped develop this program tonight. And now I'd like to welcome our moderator, Jeff Greenfield, and the members of our panel, putting the 14th Amendment to the test. Welcome.
Welcome. I believe Todd mentioned to you the compulsory purchase of my book, so let's get started. The Constitution deals with big stuff. It deals with the size and limits of governments, federal, state. It deals with the rights of individuals and the limits on those rights. It deals with powers of big private companies and the smallest and least among us. But we begin where the Constitution has its ultimate impact, and that is at the human level. So I want to tell you a quick story about a man named Roberto. Roberto is 30-something years old, lives in a small town in Mexico, has a wife, 2 children, no job, no prospect of a job, facing destitution. He is considering doing what his cousin did a few years ago and what countless others have done, finding someone to take him across the border illegally into the United States. Now we have some people here who themselves are illegal immigrants. You are here. Why would Roberto do this, based on your own experience? Why would he risk prison, risk everything, to come across the border against the laws?
A large part of it stems from the possibility of promise that I have no way of getting a better life where I am. So I'm going to throw caution to the wind and risk that with the possibility of making it and then maybe being able to send something better back to maybe family members I'm leaving behind.
Okay. Representative Metcalfe, how important is it that the United States be able to keep Roberto from coming into the United States?
Well, I think ultimately, a nation being under the rule of law, a nation that has a constitution that's the ultimate law of our land, it's important that our government actually set policies that protect that rule of law so that our citizens have respect for the very laws that are being passed that they're called to live under. If you allow people to violate your border, foreign nationals, and then violate your law day after day after day to exist within your economy, then you create an atmosphere of disrespect for the law ultimately.
All right. Ms. Wang, how important is it that the United States be able to keep Roberto and the millions like him from illegally coming into the United States?
Well, Jeff, the United States already does keep people like Roberto from coming into the United States. But I wanted to add one thing that Roberto didn't mention to the reasons that are driving people and pulling people to our country. He mentioned that there are labor market forces, vast economic pressures.
If I may, I have to be a little brutal about this. What I want to know is, how important is it that the United States be able to enforce its laws and secure its borders? We're going to get into all these issues in a bit, but on that issue, how important is it?
Well, the United States has deemed it important.
Do you think it is important? Really important? Important?
Well, I think that it is important that our laws be complied with.
Okay. Mr. Mursuli?
I think that's a no-brainer. I don't know of anyone who wants open borders. The argument about whether we should build fences, whether they should be electronic, whether they should have, whether it should be the army should be there, whatever the tools are to achieve that, we all want. Whether you are an immigrant, whether you're native born, whether you've been here since the Mayflower, you want to live in a country where you know that there's laws, you know that there's some sort of construct to your living, and that there's something that you can expect from the future. That's not the issue,
okay.
I don't think.
Well, while we've been talking, Roberto has come into the United States. And he's joined some 11 or 12 million others who are estimated to be here illegally. So let me come back to you now, Representative Metcalfe. Now that he's here, I realize you think it's important. How important is it? How much of the resources of the United States should be devoted to persuading or forcing him out?
I think first and foremost, our government should use its resources to protect the interests of the American citizen, to protect American lives, liberty, and property. And if you allow people to remain here, foreign nationals who have come into your country without your permission and steal jobs, tap into benefits illegally, have their children here who ultimately tap into the same benefits, and then ultimately take up educational resources and healthcare resources that should be used on American citizens, it's very important. And ultimately, whatever resources we have to direct at dealing with the problem, ultimately we'll gain those back many times over in the future if we actually deal with this issue the right way.
Dr. Eastman, we're seeing massive layoffs of cops, firefighters, teachers. The federal government is $14 billion in debt and rising. In this world, how important is it to say, okay, we're going to tap the resources of a tapped out government to try to get Roberto and his colleagues out?
Yeah, I mean, I think you have to look at the question the other way by applying a minimal amount of resources here, and you don't have to apply the resources to all 12 million who are here illegally. If you go after the three principal magnets, the welfare benefits, the unlawful employment, and the birth citizenship that encourage people to come here, you can do those relatively simple. A couple of high-profile employment prosecutions of CEOs from Fortune 500 companies would work wonders on altering that magnet.
Let me just say that the judge's time is coming. She is magisterially judging. There's an order to this. Now, George, if I may, you said it's a no-brainer. Now that he's here, how important is it that he's out?
I don't think it's important at all. What I think is important, listen, I believe that in the end, what the human resource of our population and the way to extract the best out of everyone is the goal of this country. It's always been the goal of this country to figure out, as immigrants come into this country, how do they assimilate? Where do they get the information so that they can participate and make this Constitution stronger? That's what I would focus on. The fact that they're here is partly their issue, but it's also partly the United States issue and part of our responsibility that they're
Ms.
here.
Wang, if it's not that important, then what does it mean to say it's really important to control borders and keep them out? If once they're in, we go, oh, well, never mind.
Well, Jeff, I think there's a smart way to enforce our immigration laws, and there is a way that doesn't work. One thing that Professor Eastman and Representative Daryl Metcalfe failed to acknowledge is the contributions of the 12 million people already here and contributing to our economy. I want to give you some numbers. The Prettyman Group did a recent study showing that there were, if every one of those 12 million undocumented immigrants somehow were miraculously removed from the United States, we would lose $552 billion in total economic activity. We would lose $245 billion in GDP, and we'd lose $2.8 million in jobs.
Now, I just want to make sure we understand something at the outset, that the policy arguments here are important. This is the National Constitution Center. So if I get authoritarian in dragging everybody back to that, you will forgive me. Or not, frankly. But that's where we're going. Okay, well, it turns out that in the Pennsylvania that we are now in up here, the voters have agreed with Dr. Eastman, Representative Metcalfe. They have elected a very strongly anti-illegal immigrant governor named Bud Miller and a legislature who are determined to do something about this. And the policy that Governor Miller has advocated is something called attrition through enforcement. What does that mean? Attrition through enforcement?
This became intense focus after the Arizona law in SB 1070. By enforcing the existing laws to the letter, that people will not take the risks. Because one of the reasons, when you're balancing the risk of coming here illegally, one of the things you consider is how likely it is that you're going to be arrested. That's true for anybody that breaks the law. It's always a factor in consideration. If we don't enforce our drug laws, it's not a surprise that we see people
now, among
increasing.
us are a group of people who raised a lot of money and worked very hard to get Bud Miller elected. I believe you are among them, correct? Why were you so passionate about this issue that you chose to devote so much time and energy and money to getting a governor elected who would, if I may, crack down on illegal immigrants? If you stand up so we can hear you.
I just feel like we're losing control of our country. You know, I follow the rules and I pay taxes, and I look at all the services that these people and their children need for schools and health care, and it just seems like we're going to get swamped. And so if I'm willing to follow the rules, I want my state government to push for rules, because the federal government doesn't seem like it's capable of enforcing the rules.
Ah, you anticipate us. So what the what the legislature passes and the governor signs is something they call the EAGLE Act, the Enforcement Assistance Guaranteeing Legal Employment. The governor says it does exactly what the name says. It simply allows the state to assist in enforcement of federal immigration laws, thus making sure that employment in the state is legal. Now, we're going to go into the provisions later, but I want to let you hear what they have to say. Section 1 says this, that if in the course of a lawful stop, a state law enforcement officer with a reasonable suspicion that a person is an illegal immigrant, it requires that law enforcement official to attempt to determine the immigration status of that individual.
That sounds like my
Section 2 and
legislation.
3 make it a violation of state law for an illegal immigrant to obtain a job or for a business to hire an illegal immigrant by violating. Now, the governor says, look, this is no new requirement. We're simply saying we're going to use the state's resource to enforce existing federal immigration laws. But as you might imagine, Ms. Wang and some of her colleagues are planning a constitutional challenge. Now, let's find out why the folks you're working with are so eager to stop this. Now, along with some illegal immigrants, we have a group of legal immigrants. Look, you're safe. You're a citizen. You've got a green card. What are you worried about?
I think this is... You know, my name is Tony Tisanagar, and I'm a proud legal alien from Sri Lanka. And my parents came over here. They spent years trying to get the proper paperwork. We followed all the rules. It's a question of fairness for us. We have gone to American schools. Tomorrow, in fact, I'm going to become an American citizen, thanks to all this education here. And the question in our mind is are we a country of laws? And should we follow them?
Now, also here are a couple of business folk. Hi, business folk. Why are you so upset about this law? They're simply saying, look, we're going to enforce the federal laws. You have to live with those laws. What's your concern here?
Well, it's important, the rule of law. It's a nice slogan. And I was driving here in my limo because I'm a businessman. And I was coming down on 95, and the speed limit there's 55. I was going 62 miles an hour, and cars were passing me left and right. So what I think is what we need to do first is the rule of law is important. And if the speed limit's 55, we should all go 55. So I think we should change the law to say if you exceed the speed limit, you should get thrown in jail for a year. Because otherwise, we have no laws. And I think that's exactly the approach that my colleagues over there recommend for immigration.
I see.
It's insane.
And I suppose the prospect of labor that increases the supply and has no legal protection against whatever you might need doesn't enter into this at all.
No, I need workers.
All right.
But,
okay, gotcha. Now, Ms. Wang, you're going to get ready. You're filing this lawsuit. And
We are.
obviously you're going to argue about civil rights, and we'll get to that. But the other major argument here in your complaint is that all these sections are preempted by federal law. Now, here come the judge. This starts with the Supremacy Clause, which is what? Which means what?
Well, I think the word supreme is in there somewhere. It is basically that the laws of the United States and the Constitution are supreme over state laws, and it's so provided in the Constitution.
So, for instance, if a state wanted to impose strict student visas, and the federal government has said to somebody, you can come in, that's a clear case where the Supremacy Clause.
Yeah, because visas are particularly part of naturalization and that process, and the immigration process. And under the Constitution, the Congress is supposed to pass uniform laws on naturalization. So that's a pretty clear case.
Okay, right. And any of us who've seen Law and Order have seen the Supremacy Clause in action when Stabler and Benson get a real lowlife, and then the smug U.S. attorney comes in and says, no, he's our witness, right?
Right.
But what about if a state law that has been passed by Governor Miller and doesn't conflict at all? It just says, we're going to do what your law says. Is there still a preemption issue, possibly?
Well, and by your saying that it doesn't conflict at all, you're kind of putting the rabbit in the hat, because determining whether it conflicts or not is a matter that comes before the courts all the time. In immigration, the federal law may occupy the whole field of the law, depending upon what the law is and the state law is. There may be a burden imposed by the state law that would interfere with the federal law. So, conflict is...
But you used a phrase there that I think is key, occupying the field.
Right.
When a decision says that, whatever the direct conflict is, what does that mean? It just means, well, you tell me.
That means that the federal law is the only law of the land, and there can be no state law. For instance, in ERISA, we've held in 99% of the cases that occupies the field. Immigration, Not totally. It depends upon what the state law is and what the federal law is, how much the field is occupied.
Well, now that
Now that that's so clear.
now that we've got the broader parameters, I want to get into the chunk of the law. This is a key one. This is Section 1 of the Eagle Act, and it's about reasonable suspicion. And it says, I have to read this because otherwise I didn't memorize it. For any lawful stop, detention, or arrest made by a law enforcement official in the enforcement of any other law, like a traffic violation, where reasonable suspicion exists that the person is unlawfully present in the United States, a reasonable attempt shall be made to determine the immigration status of the person, except if the determination may hinder an investigation. An officer may not consider race, color, or national origin in implementing this provision except as allowed in the Constitution. So, here's the situation that develops. Just a few miles here, up on 95 where you were speeding. There's a 3-car accident. And when the law enforcement people get there, they find, these are the folks in the 3 cars. In the first car are 2 brown-skinned men who are talking Spanish to each other and answer the police questions with very broken English. In the second car, there is maybe it's a Caucasian, maybe it's not, maybe it's an Asian. Hard to tell what accents they are. In the third car are 2 young Anglos who barely say anything because they are texting the exciting adventure they've been into their friends. So, we have a law enforcement group here. Hi, guys, ladies. You're the ones who are going to have to figure this out, right? For all this language, you're there. I've just described these three different automobiles, and I want to quickly poll a bunch of you. Do any of these situations give rise, you think, to a reasonable suspicion? You have a reasonable suspicion of any of those 3? Who's got a mic?
Well, the Eagle Act asked me as a law enforcement official to have an eagle eye. Are we supposed to be psychic as cops? I moved up here from South Florida to take a job in law enforcement because I liked the previous governor and thought things were pretty reasonable up here.
Okay.
But I have no psychic abilities.
Do any of you think that you have reasonable suspicion of any of these folks?
Well, first and foremost, I'm investigating an accident, and I need to see who may be at fault in that accident. And if it turns out that I have suspicion that the accident was caused by people that were not in the country illegally.
But you've been charged by the Eagle Act, any of you, to try to you're required to try to figure this out if you have reasonable suspicion. Has anything I've described given rise to a reasonable suspicion? No, but yes?
I really don't think so, because we are just dealing with a routine traffic stop. The reason that this is such a hard act to enforce is because we can often get pegged for racial profiling, and I know the act says that we're not supposed to, but...
No, the law doesn't say you can't do accents. It says you can't do national origin. But let me just pause here, because, and I'll turn to some of these folks, or if you got a quick pop, go ahead.
When we're pulling somebody over for a traffic accident, or we come to the scene after a traffic accident, and someone cannot produce a driver's license or an identification?
Yes, but you're also supposed to see under reasonable suspicion if these folks are violating immigration laws. So let me just ask something. Is there anything I've described under the law give rise to a reasonable suspicion?
Well, what one of your law enforcement officers described certainly does. If you ask for documentation for driving the car, your insurance card, your driver's license, and you're looking at the plates on it. We had a stop in Butler County where nothing was matching, and they found all the occupants were illegals. Right. Another situation when they just stopped some folks on the turnpike, and when they started asking questions, 4 of them took off running to get away from the police officer. So I think that leads you to some suspicion. Okay. And that you interface then with the feds to find out, are these folks here legally or not, and then you take the proper actions through the Eagle Act, but my act would be the Arizona model.
All right. Problem with that?
Yes, Jeff. I think as Sheriff Dubnick in Pima County, Arizona pointed out, when the Arizona version of this law passed, there is no way to enforce Section 1 of the Eagle Act without racially profiling. And there's no way to enforce it without requiring our good police officers to violate the Fourth Amendment's prohibition on searches and seizures without reasonable suspicion.
So, okay, if maybe I can turn to the fellows, I can turn to see if there's a Mexican flag flying outside on the radio antenna, that's not a reasonable suspicion on your
Certainly not. There are plenty of U.S. citizens of Mexican ancestry who might proudly want to show their ethnicity and their
Irish flag, it
ancestry.
should be St. Patrick's.
Same thing.
Okay. So other than somebody jumping out of the car and saying, I wish I had never sneaked across the fence to my home in Mexico, I assume that's okay.
Well, yes.
Whoa.
Yes.
I can't use that.
Let's flip it around, Jeff.
No,
Let's.
just stay with me for a minute.
Okay.
I think under those circumstances, you'd say the police might be able to inquire into the immigration status. You got a problem with that one? No, I don't. Okay. I realize it's not likely.
If they blurt it out.
Well, you know, I just wanted to see how far we were willing to go on that there's no way to be reasonably suspicious about this. That's all. But in fact, this all may never happen because Ms. Wang and her colleagues have brought a action to enjoin the enforcement of the law. So we're going to have the world's fastest oral argument here. Ms. Wang and then Professor Eastman, Judge, unless you want to do your... unless you're doing your Clarence Thomas impression, I'd like a couple of questions here. Ms. Wang, make your pitch.
Your Honor, Section 1 of the EAGLE Act violates the Constitution in 3 respects. First, it is preempted by Congress's comprehensive scheme of immigration enforcement. Second, it requires...
Well, except that we're talking about uniform laws of naturalization. This, in terms of detecting unlawful activity, is just helping the federal government, isn't it?
Well, Your Honor, it doesn't just help the federal government. As the U.S. government argued in the Arizona case, U.S. versus State of Arizona.
That's not before me. We have your cases before
But, Your Honor, it's the same law, and I think that what Judge Bolton did in that case is instructive. The federal government pointed out that unless the federal government takes the lead and asks the states to step in specific ways to help enforce federal immigration law, a state and local effort to enforce immigration laws may interfere with the priorities that the federal government has set.
Well, you say may interfere. This is a facial challenge. We're looking at the language of the law. We don't have any history under it, so we don't know that it interferes. We don't know that it does anything. Tell me why on its face, and it could be that reasonable suspicion is very limited. I mean, profiling is not going to work as reasonable suspicion, but somebody hightailing it off, into the woods or something, maybe it gives rise to suspicion. Our police do this all the time. Why should I say that they can't inquire when there's reasonable suspicion? I just don't.
Well, Your Honor, as we've demonstrated through the declarations in support of our motion for preliminary injunction,
which my law clerk read, but I haven't seen.
I'd like to give you an example of why it's true. As Sheriff Dupnick pointed out, it requires our good officers to go out and try to racially profile. Short of seeing someone actually hopping the border fence, there is simply no way for a police officer during a traffic stop or an other encounter to determine whether someone is illegally in the country.
Well,
Your
you
Honor, I'm
say
sorry.
that, but we use the term reasonable suspicion all the time.
That's right,
and
Your
the
Honor.
police can go into someone on supervised release home on reasonable suspicion. But that is a classic term of art.
And that is reasonable suspicion to believe someone has violated the law. In the case of a burglary, if someone has a big bag that's full of loot from a burglary, that would constitute reasonable suspicion. Short of seeing someone hopping the border fence, or perhaps, to give another example, a minivan that's stuffed with people who look like they've just crossed the desert. Short of those circumstances, you just can't tell as an officer whether someone is in violation of a complex body of administrative law.
That may be, and it may be that the application of this law is the lawful application is going to be only as to those where the reasonable suspicion of illegality is apparent. And so it could be that we strike down a lot of the activity under this, but I don't know that. These facial challenges to laws are very tough for courts to apply.
Red light.
Okay.
Your Honor, my esteemed colleague, I think, has demonstrated the issue. There's no preemption here. The state is simply trying to help the federal government enforce its laws. Even Judge Bolton in that infamous Arizona case recognized in a footnote that law enforcement officers across the land already have the discretion to stop somebody if they have a reasonable suspicion.
But isn't that a problem that the feds have discretion? So they're going to exercise their discretion in an area that's really unique to the federal government. And yet we're going to have state officers out there maybe pulling everybody over and bringing everybody in and asking everybody, therefore conflicting with what the federal government's prerogatives, i.e. the exercise of discretion, might be. Isn't there an obvious inconsistency with the state saying, you know, I'm here to help you, but I'm going to do it differently than you would do it? Isn't that inherently problematic?
It's a good example of why you never accept questions from a judge going against the other opponent and think they're going to be in favor of you. Very good. No, the Congress has set out very specific sets of laws. The most interesting thing about the Department of Justice's challenge to this statute, as with Arizona, is that it somehow has the discretion not to enforce the policy judgment of Congress. And yet we know from a number of decisions by the Supreme Court of the United States that it's Congress that has plenary power in the immigration field, not the executive department to choose whether or not to enforce our immigration laws.
So we do have Congress, and that's a lawmaking body.
That's right.
So why should a lawmaking body in the state be proposing and enacting legislation? We have Congress doing that. I still don't understand.
Well, one of the things we all agree is that the state could not create different rules for immigration, different visas. But
does Congress have, is this law the same? Does the United States have this law that
yes.
prosecutors and, you know, the, what do you call it, the federal investigators whose name is escaping me, Firearm, et cetera, Act, they go out and we have the same law in Congress?
We don't, the federal government hasn't mandated that in every instance where there's reasonable suspicion, but they've recognized that they have the discretion. All Pennsylvania is doing here is the leaders of Pennsylvania are exercising Pennsylvania's discretion for their line officers rather than each one having independent discretion on their own. But that's an enforcement issue.
I have no problem with there being two systems of immigration laws, basically.
Well, but it's not a different immigration law. It's added resources in the enforcement. If one of the reasons we prioritize at the national level is a limited resources, right. The federal government ought to be welcoming this added bit of enforcement.
Let's get to this reasonable suspicion piece. What's an officer to do? Aren't they going to, when in doubt, start inquiring? Well, they're on the spot. Are they going to be able to say, gee, does what this mean? You know, this person is fleeing or doesn't have identification. Aren't they then going to really start inquiring and they're going to jump over the reasonable suspicion part?
Well, as you yourself pointed out a few moments ago, reasonable suspicion is a term of art. We've known what it means, the Terry stop from the Supreme Court, where you can stop somebody if you have reasonable suspicion they've committed a crime or about to commit a crime.
Yeah, but
you can stop them.
Committing a crime is different from that the person's status is illegal.
Well, having
how do you
committed
do that by looking at him?
Having committed a crime. Well, one of the examples I think that was good is if I ask for your identification, you're driving and you're supposed to have a driver's license with you, and you don't have it.
You say in a foreign language, I left it home.
Red light.
Very good.
Just want to make sure that your mic is okay. I've flunked every, you know.
Can you hear me?
Is she okay? Yeah. Okay. Just, you know, I have to do everything.
It's not good to tune out judges, ever.
No, now, Judge Rendell, we don't want a ruling from you. It's a little early. But I guess the question that does come up is, how do you weigh an argument like this? What do you need to help you sort out a decision, whatever it might be?
Yeah. Well, it does relate to the questions that I was asking. And this is what we call a facial challenge, that on its face, it violates the Constitution. And you really look at the language and you have to poke at it because it is facial. Now, if it wasn't reasonable suspicion, if it used a term such as, believed that, but reasonable suspicion is a term of art. So what you need when it's a facial challenge is to really go back into the law and try to figure out whether on its face is necessarily everything. And in order to find something facially unconstitutional, you cannot imagine a situation where it would be constitutional. And here, if there was reasonable suspicion, and we decided that the intrusion, i.e. of inquiring on the person, here again, you've got a problem with, are you talking about a stop and a search, or what are you talking about? That the intrusion is not that great. You're just inquiring, and you have a reasonable suspicion they're illegal, all you're doing is enforcing the law and finding out if the law's been violated. Well, that's what they're doing in the traffic accident. But what's easier is after we've had some experience under this, and there's racial profiling, and you bring in a case, then it's easier for the court. But a lot of these statutes on their face, you know, the lawmakers are pretty clever. They can draft them so that it looks like it's going to pass muster.
Just as a matter of curiosity, is there ever a time under the Constitution, because there's a reference to this law, when...
I don't answer questions like that. Is there ever a time under the Constitution?
Have you ever, to your knowledge, do you know of any time when racial profiling has been permitted?
No.
Okay.
I mean, qua racial profiling, no. And that has been behavior and conduct that has been brought before a court and proven that this was racial profiling. No.
So what I mean is if a local authority said, look, you know, 99% of the illegal immigrants who come through this area are Hispanic, so when there's a Hispanic car stop, we're going to assume that the officer has reasonable suspicion because they're Hispanic.
No, it has to be reasonable suspicion of illegality.
Yeah.
So it has to be illegality, not just that they're from a foreign, they're speaking a foreign country. It's
and Jeff, I'll join with...
I think that the question you asked, Jeff, pointed to the inherent problem with Section 1 of the EAGLE Act, which is that it ignores the fact that under the profile of that law enforcement official, there are many, many U.S. citizens of Latino descent who will be stopped and hassled by the police and made to wait at the side of the road while everyone looks, and otherwise suffer a very serious constitutional injury.
That's a straw man argument.
I had a moment of agreement,
It's
but
not
then
a
she
straw
took it
man
away.
according to the plaintiffs in our
we
case.
have a moment of agreement.
I had a moment of agreement with the ACLU, but then she took it away. The moment of agreement... the moment of agreement, because I want to get this down on the calendar. It was the wrong question. If 99% of the people who in a particular locale are of Hispanic origin, does that mean I can stop anybody Hispanic? It's not the right question. If there was nobody who was in that locale who was legally here of Hispanic origin, then that 99% number would matter. But you have to look at the different number. But beyond that, you know, that would be illegal racial.
I want to move on. Well, take a shot.
No.
Okay. Another key part of this EAGLE Act has to do with the sanctions on employees and particularly employers. Because just the federal law says if you go out and get a job, really whoever you are, you have to have valid documentation that you're a citizen. Anybody. And the employer is required to get it. The EAGLE Act simply states that employers and employees are required to comply with those federal provisions. It doesn't deviate from them in any way. It says if an employee is found to have violated the federal provisions with false or no documentation, under this act, federal officials are notified and the worker, the employee, is subject to a state fine of $500 under the EAGLE Act. If an employer is found to have violated the federal provisions, the employer loses his license. Now, we have our business group. Okay, if you want to pass the mic to another, be my guest. So look, here's the question. You guys have to live all the time with regulations that might violate both federal and state law. OSHA can shut you down, the state folks can shut you down. EPA can sanction you, the state environmental people do. So why are you so worried about a state law that simply says the federal law applies to you? If you want to do it, if somebody else wants to, go ahead.
Well, I try to do what I need to do to keep my little dry cleaning business going. But it's hard, hot work. And if people come to me and they've got documents that look right, I'm going to let them work there as long as they can take it. Because that's what you have to do to keep your business going. Besides that, they keep talking about if the law is legal or not. Sometimes you got to ask if the law is right or not. Have you heard the stories of these people?
Okay.
And besides, you know, y'all did NAFTA, which didn't do my business any good, and it's bleeding them by, you know, you do NAFTA, maybe we ought to open the borders. They're good workers.
Thank you. Well, the point about this is that it kind of looks like the state has tried to write a law that says this state makes it a requirement that you follow the federal law. Is that pretty much, Representative Metcalfe, when you are looking at state laws, that that's what you're doing?
The E-Verify system that we would mandate in the law that they actually utilize is a federal system that's been made available for employers to utilize. And some states have already passed a law mandating that their employers do use E-Verify to check out the identification is being given, and that's what we're hoping to pass in Pennsylvania also, is to require employers to use the E-Verify system. But a lot of the employees that are being hired, it's with a wink and a nod situation. I mean, they're already required with the I-9 form to also ensure that they have the proper documentation, whether it's Social Security card or driver's license or birth certificate. But there's a lot of employers, like the young lady down front, that are giving a wink and a nod because she does need employees. And I think that's one of the magnets, it's one of the economic faucets that's been turned on that's drawing illegal aliens into our country. So the business owners who are doing that are some of the prime culprits at fault for drawing the illegal aliens into our country.
Could you use the mic? You got the
mic?
mic?
It is. By law, it is.
It shouldn't be our job to check. It
Well,
shouldn't be our job.
you
Isn't
have
it
to take
the
that argument
federal
back many
government's
decades.
job? You shouldn't let them in. We're just trying to do our job. It's not our job to check.
But
That's your job.
Patriotic business owners wouldn't help the cause.
Was playing the red, white, and blue card, right? Okay. Look, so here, George, just let me phrase it.
Okay, sure.
All they're doing is saying, you guys got to follow federal law. And you have a problem with this?
No, not at all. In fact, I think that the unfortunate part of this whole discussion is that we're trying to plug the dam with Band-Aids. And as long as you continue to try to fill the hole of the dam rather than rebuild the dam so that it functions correctly, we're going to be having these kinds of conversations and these kinds of conflicts. You talked about protecting the legal citizens and protecting their futures here in the United States. Well, you just saw an example of someone who inadvertently would get impacted by that. Cecilia talked about those individuals like myself. You know, you're not going to get stopped. I don't care unless you run.
I've been stopped.
Okay,
before. He will if he comes out. I've been stopped many times over the years.
You know, we register over 100,000 people around the country in 11 different markets. I have yet to run into one person, legal or otherwise, who doesn't want to learn how to live in this country, to work hard, and to do what they can to be part of the process. And I think we're having the wrong argument. We're having the wrong discussion. Let's have comprehensive immigration reform. Let's close up the borders. Let's decide what to do with the 12 million that are here. Let's provide businesses with an opportunity for working visas when and if necessary. And let's call it a day. And let's stop trying to do this Band-Aid situation that all it does is we're having very civil conversations. This is one out of many. Most of them are not civil conversations. And what ultimately happens is that people are being hurt. They're being physically hurt, they're being emotionally hurt, they're being economically hurt, and those are Americans, not just illegal. These are people who are here, who have worked their whole lives, who are now having to suffer through some of the things that are going on, like Arizona and elsewhere.
Real life intrudes on these conversations happily, and then we say, okay, I still want to focus on some of these constitutional matters because that's where we are.
I hear you.
I mean, that's fine. You know. But here's a question I have for those of you who think that there's something about this whole issue that intrigued me. In a Supreme Court case involving an Arizona law very much like the Eagle Act, Justice Scalia suggested that if the federal government was in fact not doing what it was supposed to be doing, then that might open the door to states doing it. Do you sympathize with that argument?
I certainly do. I mean, that's part of the argument that we've made year after year after year as I've joined together with my colleagues across the country through State Legislators for LegalImmigration.com, which has 41 states working within that coalition now to try and encourage the federal government to work with us than working against us. They have a clear responsibility in Article 4, Section 4 to protect the states from invasion, and they've not done that. When you have hundreds of thousands of people coming across your border every year, it's nothing less than an invasion.
But I'm asking, I think, a more legal question. That is, what Justice Scalia seemed to suggest was there is a point at which the failure of the federal government to exercise its preemption permits the state to step in. I'm asking, do you think that's right?
I do think that's right, and the Supreme Court's been pretty clear. There's kind of two sides of the spectrum here. States can't make their own immigration policy, but they can address the collateral impact of a failure of immigration policy because of the impact it has within the state. And it's between those two that these statutes are falling.
Here's what occurs to me about that. We have a mayor in New York who is very assertive about the power of government to not let you eat the wrong food, not smoke anywhere. So imagine that Mayor Bloomberg one day says, you know, we got this airports. And the TSA is awful. They invade your privacy and they let people on with box cutters. I got a great police force. I got a great commissioner who knows about terrorism. So starting Monday, I'm sending my own TSA team out to LaGuardia Airport to enforce the law that the feds can't. You got a problem with that?
You know, I do. But because the plane that takes off from LaGuardia is going to land in Philadelphia, a different state. It's not the state protecting its own interests. If they set up a separate check for the plane taken off LaGuardia, flying up to Albany or Rochester, then you have a state issue, and I think the existing law would allow Mayor Bloomberg to take up that protection.
Judge Rendell, there's an interesting area here. If Justice Scalia is right, and we talk all the time in law about the slippery slope, are we slippery and sliding?
Yeah, that's what comes to mind indeed, because what if the government isn't doing a good job with the Army? Does that mean Pennsylvania starts its own army? I mean, there are areas of the law that are uniquely federal, and the Constitution maps out those areas. And I guess the question in immigration is whether the uniform law of naturalization, how far that covers. But it is thought to be a federal power, just like Mayor Bloomberg, what's thought to be his domain is police power, traffic, things of that kind that don't have federal implications. Once you find federal implications, I think it is a slippery slope to say, but if the feds aren't doing what we concede to be a good job.
Well, here's another way, and I'd like to see for you to weigh in on this. Let's say, because I want to know how far this notion goes, that once the federal government has set something up, the states just can't do anything. West Virginia is looking at this, looking at Arizona, looking at Pennsylvania, our Pennsylvania, and says, look, we really want to do a law that is just immune from constitutional challenge on supremacy clause and preemption grounds. So here's what they do. They create a state law with requirements for workers and business people that is absolutely identical to the federal law. And then they make their penalties, civil fines, identical. And they also say, if you've paid a federal fine already for this violation, the state fine is waived. Now, in other words, it says, we're simply going to enforce the federal law, same penalties, no double jeopardy. Is that preempted?
Yes, Jeff. And this is an easy one. Section 2 of the Eagle Act is definitely preempted. Thankfully, not everything Justice Scalia thinks is the law of the land. And the law of the land here is that if Congress has occupied the field or has expressly made provision for this area, any state laws are preempted. Regardless of what my opponents across the way here think about the job the federal government's doing, Congress in 8 U.S.C. section 1324A H2.
My favorite.
Your favorite? The businesses probably may or may not agree. Congress provided for sanctions for employers. A state, even if it enacts the same exact provision, is going to have state prosecutors and state officers deciding how to enforce it, what kinds of settlement agreements to reach, and otherwise is going to interfere with Congress's decision and the executive branch's decisions about how to implement that law.
Which raises an intriguing question, I think. I believe I'm right in saying that if the Congress chose to pass a law, it could deal with all these questions by affirmatively saying to the states, we want you in on this. Mm-hmm. Not a constitutional problem here. So would that, why not?
That's not the question. And the issue that's been raised, this particular statute has a preemption language, express preemption language. States can impose new penalties. But the exempt from the exception from the preemption language is, but the states can use their licensing. So they can withdraw the license, which is what Section 2 of the Pennsylvania statute you read does. So that Congress has made the deliberate judgment not to preempt. The backdrop principle here is important. Congress, in the exercises of its power, can affirmatively preempt state action. If it has not done so, the rule is that the states normally get to continue to act as governments. They're not just potted plants administrators for the federal government when the federal government says so.
Why do I have a feeling you don't agree?
I don't agree. A couple of things. I respectfully disagree with Professor Eastman. First, on Section 2, the employment sanction provision, Congress has said that the states shall not legislate in this issue. Slapping another name on a fine and calling it a relicensing fee does not do the trick. Second, Professor Eastman a few minutes ago said, we need to look to what Congress said. So I want to go back to Section 1 for a minute. Congress has actually legislated on the issue of when state police officers can get in the business of immigration enforcement. That's in Immigration and Nationality Act, Section 287G. And Congress made specific provisions for when it can ask state or local agencies to get into agreements to enforce immigration
But
policy.
again, I think that has the very nature of our federal system backwards. Those statutes authorize the Attorney General to deputize state officials when the Attorney General deems that he wants additional work. It doesn't prohibit the states from exercising their state sovereignty on their own. We're going to find out in the next couple of months, because this, as you know, is this very issue is before the court right now.
Judge Rendell, I promise, I'm not looking for a ruling. Promise.
I am.
I promise. But what I'd like to know as you hear this debate, if you can spotlight, and to some extent you have already, what's the trickiest part of this? Where's the part where you think you really get, the judge, whether you or someone else, is really going to have to go back and wrestle really hard with this?
It's what is conflict, what is interference, what is burden. To have two laws and to say the state is merely enforcing, it's just saying the federal law becomes another state violation. Here again, on its face, you might say, well, okay, there's no interference, there's no conflict shown because it's identical, as you point out, it's identical. How could there be conflict? How could there be interference? How could there be burden? And the idea that enforcement and prosecution, well, that's hypothetical. You might be able to say that on its face, it's okay. But as applied, there are probably going to be some problems.
Let's move on. And one person we have sort of left is Roberto. So I'd like to bring you up to date on what has happened. Roberto has found work, the kind of work that illegal immigrants tend to find, is day jobs, landscaping, painting, carpentry, and he's sending most of the money back home. There's an opportunity for his wife, Maria. There's a billionaire.com person with political ambitions who needs a nanny. I just made that up. And so Maria, leaving the two children with the grandparents, comes to join Roberto. And shortly after Roberto and Maria are reunited, Maria becomes pregnant. Under the Constitution as it is currently understood, when Maria gives birth to Victor, what is his status, the child's status?
The citizen.
Because that's what because the 14th Amendment says he's a citizen. Now, okay, baby Victor is a citizen, an anchor baby. Does that mean that mom and dad now get to stay in the United States because their son was born here? George?
I don't think that's the reason they get to stay in the United States.
Well, I'm saying, under the law, do they get to stay here because their child was born in America?
No.
Okay. In fact, that child has to be, I think, 21 before he can apply for this visa for his parents. Okay, so
And then
that's
it's another 10 years before the parent can come back into the United States.
So before we get to the law, we heard a policy argument. Here about what we ought to be doing. So forget the law for a moment. As a policy argument, birthright citizenship for the children of illegal aliens. Why is that an important issue to you?
Because it's one of the main economic incentives for illegal aliens to cross our border. To have a child here, have that child granted citizenship automatically, even though it's being born to foreign nationals who have not entered our country in an authorized manner. And then that child is automatically due to be able to collect food stamps, the welfare cash assistance, the free American education, and that the parents then have that sustenance that's granted to them through their child that helps them to remain here illegally. That they actually, if you have any American family that actually has their child living in an environment where the family's violating one law after another every day to exist within our economy, whether it's transportation laws, labor laws, insurance laws, if you have any other family having their child put in that environment, that child would be taken away by the youth services. But we let illegal aliens come into the country, have children here, and then grant them that holy grail, if you will, of citizenship for that child that then anchors that family here in a manner.
The folks who helped put Bud Miller in office are strict immigration people. You have feelings about this issue about anchor babies? Is this one that you feel is part of the main reason why you're, well, you tell me.
Well, it affects everything. I think that we're importing poverty. Roberto and his wife are now here. They have a baby. Well, you know, I'm poor too. I'm not very educated. And the work that I could do is the work that Roberto is doing. And so I saw Roberto take my job. And so now it's hard for me to provide for my family, for my babies. And yet he has my job and now social services for his baby that could go to my child. And I'm a U.S. citizen. So why should they go to him and not to my children?
So putting the Constitution aside for a moment, the impact of anchor babies, you've heard two arguments saying they're burdens, that's unfair. Your response?
Which anchor babies do you want to talk about? The ones that graduate summa cum laude out of Harvard, or the ones that, I mean, you're taking a term, right? And you're making a decision on a child and politicizing what is not a political issue. You know, I would completely disagree with you. We speak to millions of Hispanics every day. I have never met somebody who came here to have a baby. People have babies when they have them as part of their life, but nobody maybe some people did. But there's no evidence to suggest. In fact, the Pew studies that have come out completely argue that, throw that argument.
I think you violate common sense to even deny it. You violate basic common sense to even deny that it's an attraction.
Maybe your common sense.
No, I mean, I think the attraction of the majority of Americans that agree with me.
How many immigrants do you know?
Quite a few. My wife is an immigrant.
Okay, all right. And so how many?
My wife did it the right way. She didn't try and steal the American dream. She did it the right way, through the process.
Right. We had that option.
She had that option, as many people do that are waiting in line to get here while other people are violating our borders and invading our country.
Exactly? Everybody keeps talking about that line. Where is that line? What is that line?
Well, you know, I mean, as you well know, depending which nation you're from, it might be a different line. But there is a line. There's a right way to do it. And somebody that violates the border and does it illegally, that jumps the line and tries to steal the American dream, instead of working properly for it and working through the rule of law for it, is exactly what we're trying to address.
And I do think the evidence is rather compelling, certainly along the border states and the border cities. You look at the public hospitals in El Paso and Tucson and San Diego, overwhelming large percentage of the births in those hospitals given to folks who have come across the border illegally. The anecdotal evidence of people driving around the parking lots until they go into labor so that the child will be born in the U.S. hospital rather than back on the other side of the border. Yellow page ads in the Los Angeles area of a birth tourism industry all indicate it may not be as big a draw as employment or the social services, but it is certainly one of the three principal draws for illegal immigration.
I'm going to, if I may, go ahead.
Jeff, I think this is very important that we be clear about what this proposal is. This proposal is to repeal the citizenship clause of the 14th Amendment, which we earned through the Civil War.
Which we are getting to right now.
Okay.
I promise you. I just need to, I don't want to put the cart before the horse, whatever side of the border it's on, because I need to set this up. This is the 14th Amendment Citizenship Clause. I mean, I'd like to, you know, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Judge, at the time this was ratified, right after the Civil War, what was the point?
Well, it was right after the Civil War, and the point was to make sure that children of slaves would be citizens.
Okay. Now, congratulations.
Thank you.
You are now a U.S. Congressman, or deepest sympathies.
I don't know if that's a promotion or not.
I want to focus on the federal efforts at the federal level, not the state level, to deal with the 14th Amendment Citizenship Clause. I believe you would like to see federal legislation by statute to change the birthright citizenship. To say what?
To ensure that subject to the jurisdiction thereof is given the weight that it should be in the decision as to whether or not grant somebody citizenship. It's totally being ignored now, whether or not somebody is subject to the jurisdiction thereof, as it was debated by Congress originally when the amendment was adopted, as it was ratified by the states, that it meant that your parents had an allegiance to the United States of America, not that they were foreign nationals invading our country, having a child here. That, I mean, from a policy perspective, it totally undermines the future of our nation to continue to grant citizenship to individuals whose parents have no allegiance to this country and have invaded our country illegally.
But now we're talking about the 14th Amendment. Can you shed some light,
Sure.
Dr. Eastman, on this particular clause, under the jurisdiction?
Subject to the jurisdiction thereof, and it's ambiguous. Justice Alito, during his confirmation hearings, was asked, is this a well-settled question that you can talk about? And he said, no, it's never been decided by the Supreme Court. Let me put it this way. We think subject to the jurisdiction means everybody that's within our borders because they have to follow our laws. And so think about an English tourist who's here for a month visiting in Philadelphia and looking at Independence Hall and regretting the colonies that they lost. He is subject to our laws while he's here. He has to drive on the right side of the road rather than the left side of the road. But he's not subject to the more broad jurisdiction that was intended by that phrase. He can't be drafted into our army. He can't be tried for treason if he takes up arms against us. It would be a crime, but not treasonous because he doesn't owe allegiance to us. And when the drafters of that provision were asked, what do you mean by that? Partial or territorial, that limited jurisdiction, or the more complete one? They said the more complete one. And that's what we're trying to do with the 14th Amendment statutes, is just remind us what the 14th Amendment actually says. Two components, birth and being subject to the jurisdiction, and they're not synonymous.
Just to be clear at this, it's not that someone stopped on the New Jersey Turnpike can jump out of the car and say, you can't touch me, I'm an illegal immigrant.
No, they're subject to our territorial jurisdiction.
Okay.
Yeah.
Is he right?
He is absolutely wrong. It's clear from the plain text of the 14th Amendment. Subject to the jurisdiction of the United States means that you are required to obey our laws and that the government can assert its authority over you. An immigrant, whether undocumented or lawful, is subject to the jurisdiction of the United States. He is wrong on the legislative history. Both the framers and the opponents of the 14th Amendment were crystal clear about what that meant. And with respect to Judge Rendell, they were primarily motivated by trying to grant citizenship to make clear that former slaves and their descendants had U.S. citizenship. They were also concerned about children born to immigrants. And I want to go into the language that Professor Eastman is talking about. Senator Cowan opposed the 14th Amendment, and he said to the proponents, including Senator Howard, if you pass this amendment, why even the children of Chinese people in California will be citizens of the United States. And Senator Howard said, yes, that's right. And then Senator Cowan said, if you pass this amendment, even gypsies in Pennsylvania will be citizens of the United States. And Senator Jacob Howard said, yes, that's right. The framers of the 14th Amendment had an inclusive and expansive view that fundamentally changed the original document to embrace anyone born in this country. And because of the framers' wisdom in doing that, all of us sitting here in this room, whether we are the children of an immigrant, grandchild, great-grandchild, if your ancestors came on the Mayflower, we are all equal before the law and the Constitution.
Yeah, that's just completely... That's just a complete distortion of the legislative record. Look, the issue presented, that first of all, that discussion doesn't even occur on the 14th Amendment debate. It occurs on the 1866 Civil Rights Act debate, which is even more clear. The language said that all persons born in the United States and not subject to any foreign power. The reason Howard responds the way he does is we are no longer going to have ethnic background as a criteria in limiting our jurisdiction. Anybody who is here lawfully and permanently and owing allegiance to the United States and not to any foreign power will be citizens without regard to their national background. The Chinese and the Gypsies he were referring to were here lawfully and permanently. There was never an issue. Where we get to the question of somebody not owing allegiance to the United States were Native Americans who owed allegiance to their tribes. The tribes themselves owed allegiance to the United States, and they were very clear that the children of tribes of Native Americans would not be citizens because they were not subject to the complete jurisdiction. That required an act of naturalization beyond mere birth.
I know it's frustrating. If this were C-SPAN, we'd go on forever, but we're not. So what I have to do is fast forward to the passage of this law, somehow, in this political world, but a rejection by the Supreme Court by a 6-3 vote. They said, no, we are sticking with the traditional understanding. So now there's one more step that we want to talk about, and that is a push for an amendment to the 14th Amendment. How do you do that, Judge Rendell? How do you amend the Constitution?
It's not easy. Under the Constitution, you need either 2/3 of the Congress or 2/3 of, I think it's state conventions.
Legislatures.
State legislatures. And then, if that has happened, one or the other, you still need 3/4 of the states to ratify. So it's pretty tough.
I have a question for you that should we get to that point, you were talking about a kind of incivility that has crept into our political conversation about illegal immigrants. Do you fear that if that became an issue, amending the Constitution to strip away birthright citizenship, that would add to the fuel to the fire that you're concerned about?
Absolutely. I mean, I think one of the things we're seeing, that I'm seeing more and more, is legal immigrants, particularly Hispanics. Nobody's really having this conversation about the Chinese or the Canadians or the Swedes. I mean, let's be really clear here. We're talking about Hispanics.
I have.
Okay. You and 2 other people.
Me and most every one of the state legislators
anyway,
that's working with
Can
me.
I finish? Mm-hmm. Thank you. And so I think that when you are questioning my existence, when I as a U.S. citizen, living in a world where the dialogue, we're no longer having conversations about policy A or policy B. We're having conversations, we're seeing ads, Sharon Engel's ads in Nevada, where she had visuals of these creepy looking guys with flashlights and bandanas and, crossing over the border in Nevada. No, somebody forgot to tell her Nevada doesn't have a border with Mexico. But, so we're no longer having this conversation. The fact that we're talking about the 14th Amendment, the fact that we're talking about SB 1070, the fact that there's 60 states and municipalities that have these copycat legislations, this is way beyond fixing what was a real problem that we can all agree is a real problem in this country. That's not what it's doing. All it's simply doing is fueling the fire for political agendas and for people's careers, when the solution is really at the federal level to clean up the mess that they've created.
Question for you now, Congressman Metcalfe. Obviously, you're a strong proponent of restricting illegal immigration in a variety of ways. Does amending the Constitution raise for you, I mean, I don't know, a question of the means and the ends? That is, playing with the Constitution, whatever it is a very serious act. Would you have a problem, no matter how much you wanted to see this done at the statute level, saying, I'm just not sure about the constitutional amendment part?
There's many of us that serve at the state level that are very frustrated with the courts, because many times we see such judicial activism that we believe that they go far over where their boundaries clearly are, and that they're actually not upholding the Constitution, but they're undermining it. So if it gets to a point in the United States of America where we have to pass an amendment to the Constitution to actually fix the problem that we should be able to fix through a statute, then myself and many others will be advocating that through our state legislatures.
Okay. Oh, no, I
don't. Judicial activism, what did I do wrong? I'm just sitting here on a plot of land.
You're in the middle.
Well, here's what I think we're at this point, as we're coming to our last moments. Clearly, whether for good or ill, a national debate about amending the Constitution is going to really grab the attention of at least that part of the American public that is paying attention. And these opinions are held passionately, as we've seen tonight. So here's what I'd like to do in the last moments before we wrap up. I would like Mr. Mursuli and Representative Metcalfe to make their arguments, but to make them to the groups that feel just as passionately against. So, Representative Metcalfe, these are the immigrant fellows. These are the immigrants. Some have been here legally, some illegally, but particularly the legal ones, as you well know, believe that what is really fueling a lot of this energy is, frankly, ethnic or racial hostility, not rule of law. So what I want you to do is talk to the immigrant constituency and explain to them why you feel as you do. And then we're going to hear from the other side.
To the immigrant population, I would certainly appeal to those who have immigrated here the right way, that you've had to go through the process, that you've had to wait in the lines, that are around the globe to get into the United States of America, to pursue the American dream the right way. But to those who are here illegally, who aren't immigrants, but who are violating our borders, who are here as illegal alien invaders, I would say you have very little impact on my public policy decisions, because you shouldn't be taken into consideration. It's the American citizens' interests who should be taken into consideration. It's American lives, liberty, and property that need to be defended against those who are here, foreign nationals who are here illegally, violating our laws, violating our Constitution, violating our border, many times committing one crime after another against American citizens. So to the immigrants who are here, who are legal, who are resident aliens, who hope to be naturalized, or maybe not naturalized, but hope to remain here as resident aliens, working within our economy, enjoying the American dream as a resident alien, I would say that the majority of you ultimately would be on my side, on the side of the majority of Americans, as one poll after another has shown, that supports the Arizona legislation and the model that we've introduced in Pennsylvania and many other states around the country.
Here are people who have spent time, energy, and money electing a governor and a state legislature that wants to make the crackdown on illegal immigration a prime concern. I invite you to take roughly the same amount of time and explain to them why you feel as you do.
First of all, I want you to know that as an American patriot, because I am an American patriot, I understand the sense of confusion and maybe the anxiety that lies innately in having the country appear to be changing in front of your eyes. I do believe that we all should expect to walk down the street and have a sense that no matter where you're from, you do have an allegiance to this country, and that you do have an interest in the interests of Americans. And sometimes, without knowing everyone, that's reflected on the way they look or the language that they're speaking. But I guarantee you one thing. When I am dancing salsa, and when I am talking in Spanish, I am no less of an American than when I'm in the Constitution Center in Philadelphia. And I think that as Americans, what we should, there have been mistakes made. The federal government throughout the years, and we as citizens, have gainfully employed people that maybe shouldn't have been here. But that is done. The question is, how do we correct the situation? And let's keep correcting the situation in a way that strengthens that Constitution and not weakens it.
Judge Rendell, I want you to have the last word because you have contempt power. No, but I think it's important to now pull the perspective back. There was no such thing as illegal immigration 200 years ago. There was no such thing as illegal immigration when my grandparents came here a century ago. So in what sense, then, how do we look to a document like the Constitution, not to decide this issue, but to tell us how we should think about this issue? What guidance do we get from this now 223-year-old document?
You know, when I look at the Constitution and deal with the Constitution, I do try to think about what was animating the founders when they did certain things. And I was talking to our group this morning about the Fourth Amendment and the fact that as you read through the Constitution, almost everything that's there is a reaction to something they did or didn't like, or a situation that was or wasn't right in where they came from. And if you read the Constitution along with the Declaration of Independence and the grievances against George III, you can kind of match up these things. So trying to imagine what the founders would say about the fact that we have people coming to our shores, I mean, that's what they were. They came to our shores, and they were foreigners. You know, they weren't illegal, but then again, they didn't totally live with the rule of law. They threw out all the tea in the Boston Harbor, and they didn't like the Stamp Act and all those things. So, but they loved the individual liberty. They loved the pursuit of happiness, and I think the founders could understand the predicament we have. But there was a tolerance that was a hallmark of the founding of our country. There was the ability of people who were freedom-loving. And so when we put everybody illegal immigrant in a big pot and say, you know, you're necessarily, you know, bad, well, if they came here for freedom-loving and they came here to be part of our society because they were in an oppressed country, and I perform naturalizations, and a lot of people from oppressed countries, maybe they don't get asylum, but they came here for a better way of life, somewhat consistent from the Founding Fathers. On the other hand, the Founding Fathers were very concerned with things like treason and allegiance to the country. So if we do have people here who are not going to be law-abiding and not going to have allegiance to our country, I think that's inconsistent. But they never had to confront this issue. They were an orderly group. They did want order, and that's the way the Constitution is set up, to have order, to know what the states can do, what the Congress can do, what people can do, what the government can do. So here we have a situation that is suddenly not orderly. And I think in the modern era, we got to figure it out. We got to figure it out.
You know, you're not allowed to be at something like this without quoting Alexis de Tocqueville. He famously once said that, I'm paraphrasing it, but sooner or later, every great political issue in the United States becomes a constitutional issue. And if you think about it, the history of these decisions, from Marbury versus Madison, can the courts overrule a federal statute? Can the Congress, how much power does the Congress have over commerce? That's resonating even today with healthcare. Slavery, the emancipation and then disemancipation of black Americans. Labor, the power of private corporations. The second civil rights revolution. Women's rights. Abortion. How the state legislatures have to build themselves politically. Gay marriage. And it is astonishing, you know, that when you think about this, and now, you know, right smack at the end of this discussion about illegal immigration, we're dealing with basic constitutional issues. And so when John Marshall said, we never forget it is a constitution we are expounding, you know, that resonates right to this conversation. And it's one of the reasons why this place, to me, is so magic, this National Constitution Center. Because here is this 223-year-old document that in some sense is defining almost every major political issue we face, which is why I think I am particularly grateful to the men and women on this panel and to the fellows and to you for coming out tonight and having a civil, vigorous conversation about illegal immigration and the Constitution. Thank you all. You can go.